I'm discussing today the prohibited personnel practices. Prohibited personnel practices are prohibitions that offend the merit system. There are 13 prohibited personnel practices. Here I'll be discussing 11 of the prohibited personnel practices. Most federal employees and applicants may file complaints with the Office of Special Counsel alleging any of the 13 prohibited personnel practices. First, I want to discuss the potential remedies for employees who have been subjected to one of the prohibited personnel practices. The general remedy is to put the employee back into the position they would have been were it not for the prohibited personnel practice. So let me give you an example. And if an employee has been suspended improperly, that suspension would be removed from the employee's record and the employee would be paid for the amount of salary that they lost. Another type of remedy is attorney's fees. If the employee is represented by counsel in their prohibited personnel practice case, they may also be entitled to attorney's fees under the remedies provision. A third type of damages is what's called compensatory damages. Those are damages that would cover things like pain, emotional distress, and stress for undergoing one of the prohibited personnel practices. The other authority that the Office of Special Counsel has with respect to prohibited personnel practice allegations is to seek disciplinary action against officials that have been accused of engaging in one of those prohibited personnel practices. For instance, an official who has retaliated against an employee wrongfully may be subjected to anything from a letter of reprimand to removal from federal employment. In general, the prohibited personnel practices fall in several categories, and I'll be discussing them in those categories. The first category of prohibitions deals with discrimination. The first prohibition is one may not discriminate against an employee on the basis of any protected class. Those classes include, for example, race, gender, ethnicity, religion. It is important to note that at each agency there exist process and procedures to handle discrimination complaints under the Equal Employment Opportunity process. It is the Office of Special Counsel's policy, in order not to duplicate those procedures that are already in place at agencies, to inform employees to use those procedures when filing a discrimination complaint. OSC does review discrimination complaints in two specific classes that are not covered by the Equal Employment Opportunity procedures, and those are discrimination based on political affiliation and marital status. Let me give you an example. Under discrimination based on political affiliation, an employee's supervisor discovers that the employee is a member of the Green Party, and soon thereafter he begins to take actions against that employee, including, for example, lowering that employee's performance appraisal rating for that particular period. Another prohibition that's included under this general discrimination category is a little bit related, and that's a prohibition against coercing an employee's political activity or retaliating against an employee for engaging in political activity. Let me give you an example. An employee contributes funds to a particular candidate or party, and the supervisor discovers that that employee has contributed funds. After that, that supervisor begins to deny that employee some privileges of employment. For instance, he removes his teleworking conditions. He denies that employee training. That would be an example of discriminating against an employee for engaging in political activity. The next area of discrimination that's covered, it's the 10th prohibited personnel practice, and it includes discriminating against employees for conduct that does not adversely affect the employee's work performance or the performance of others. This particular prohibition, we review allegations of sexual orientation discrimination. Let me give you an example. An employee is gay, and his supervisor discovers that during the course of the employment. And after that, the supervisor begins to take some personnel actions against the employee. For instance, the employee comes in 5 minutes late one day, and the supervisor decides to issue a letter of reprimand, while other employees in the same office often come in 5 minutes late, and yet they are not issued any similar disciplinary actions. The next category of prohibitions covers hiring and promotion practices that offend the merit system. The important thing to note with respect to these prohibitions is that almost all of them require a showing of intent. So these are not prohibitions that can be engaged in inadvertently. I'll be giving short examples for each of these prohibitions, which may be misleading because the investigations into these types of allegations are very fact-intensive. The first prohibition is that one may not solicit or consider an employment recommendation that's not based on the employee's work performance or their character. This particular prohibition was intended to remove political interference in the hiring and promotion process. Let me give you an example. A congressman contacts a federal official who's hiring an employee and recommends that that official hire a constituent. That congressman does not have personal knowledge of the constituent's work performance or of their character. That would fall within this prohibition. On the other hand, recommendations from colleagues, from other supervisors at the agency would not fall within this prohibition unless there's an element of political interference. The next prohibition states that one may not deceive or willfully obstruct an employee's right to compete for a position. It doesn't have to be a federal employee. It can also be an applicant for federal employment. Before I give you an example, I'm going to discuss the following prohibition because they're related. That prohibition states that one may not influence a person to withdraw from competition. Let me give you an example. We have a veteran who is at the top of the list for hiring, which means that he's blocking other candidates for employment prospects for this particular position. And the selecting official calls the veteran in and fails to tell the veteran that he's at the top of the list. Instead, he encourages the veteran to apply for another position and at the same time influences the veteran to withdraw his name for consideration for that particular position. That would fall under both of these prohibitions. The next prohibition involves the granting of an unauthorized employment preference. There are two elements involved in proving this particular prohibited personnel practice. The first is the granting of that unauthorized employment preference. The second is that the granting of the preference must be to improve or injure a particular person's employment prospects. Again, this particular prohibition involves a showing of intent. As an example, a preferred candidate, let's say a selecting official, has one particular candidate who they think may be the most qualified candidate for the position. That by itself will not violate this prohibition. Let me give you an example of a potential violation. A selecting official has a preferred candidate for a position. The position is an investigator position. However, the preferred candidate is an attorney. And when the announcement is issued for the investigator position, the attorney does not qualify for the position. The official has the announcement rewritten to include legal requirements such as legal analysis and writing and litigation. This is not something that is needed for an investigator position, and ultimately the attorney is hired for the investigator position. That is a shorthand of potentially a manipulation of the system that would fall within this particular prohibited personnel practice. This can also involve redefining the scope of competition. These particular prohibitions are of those that I mentioned earlier that are very fact intensive and require in-depth investigations. The next prohibition in this improper hiring and promotion area involves nepotism. For those of you who aren't familiar with nepotism, that is defined as the appointing, hiring, or advancing of a relative into a position. It also involves advocating for the employment or advancement of a relative in a position. So, for example, if you are a supervisor and you are in the chain of command of your spouse, and you direct that the direct supervisor provide your spouse with a bonus, that would certainly fall within this nepotism prohibition. So it goes beyond hiring. It also has to do with the benefits and advantages of employment. The last prohibition under the hiring and promotion area deals with veterans' preference. Now, this particular prohibition, the Office of Special Counsel is limited to reviewing for disciplinary action only. So there are certain veteran preferences that are required by regulation and by statute. If a veteran believes that one of these preferences has been violated, then they need to file a complaint within 60 days of the action occurring with the Department of Labor. However, they also have the ability to file a complaint with the Office of Special Counsel for disciplinary action against the official who is engaged in not following the veteran's preference requirements. An example of that is a veteran's preference requirement may sometimes place a veteran, depending on points, at the top of a list of a certificate of eligibles. These are candidates for a particular job. If someone fails to provide the veteran the appropriate points intentionally to obstruct them from raising to the top of the list, that could be an example of a veteran's preference prohibition. The last category of prohibitions don't fall into any particular category. The first one is one that we refer to as a catch-all prohibition. It's the 12th prohibition. It has a rather long definition, which I'll quickly give you, and then I'm going to give you two different examples that fall within this prohibition. It's a violation, it is a taking of a personnel action that violates a law, rule, or regulation which concerns one of the merit system principles. What does that mean? The merit system principles are general principles by which one should treat all federal employees and officials with respect to hiring, promotion, your constitutional rights. So the way that this particular prohibition works in practice is there are regulations, for instance, on providing employees yearly performance appraisal ratings. So an example is if an official fails to provide an employee with a performance appraisal rating, because that is required by regulation and it concerns one of the merit system principles, that falls within this prohibition. Another very separate type of allegation that falls within this prohibition falls within the First Amendment rights of employees. So if an employee writes a letter to the editor in their personal capacity and management takes an action against that employee because of the content of the letter to the editor, and that content is a matter of public concern, that also could fall within this prohibition, and the Office of Special Counsel may be able to seek corrective action for any action that's taken against the employee. The final prohibited personnel practice is one that was recently added under the Whistleblower Protection Enhancement Act. And this prohibition states that agencies may not implement or enforce non-disclosure agreements if those agreements do not make clear that employees have the right to engage in whistleblowing. So, for instance, if your agency has a general policy that you may not disclose any information that you learn of during the course of your job, That policy has to include language that makes it clear that you as a federal employee have the right to engage in whistleblowing and to file disclosures with the Office of Special Counsel and other entities. That would be an illegal non-disclosure agreement under this prohibition. I hope that this short video on 11 of the 13 prohibited personnel practices has been helpful. There's a short accompanying video that deals with the 2 prohibited personnel practices that cover retaliation.